evening, everyone. We're just waiting for Will. He's lurking in the shadows somewhere. So just whilst we're waiting for Will to log in, here he is. So hi everyone. How you at, Will? Just the usual blurb, guys. We've got some questions in already, which is great. Just don't disclose personal information in the chat. Just make it out like the questions about someone else, and then just get around that issue. Hang on a minute. Always do that. So yeah, basically a few other bits as well. So when the recording goes onto YouTube, I take the live stream chat off, just as a way of, just as I say, I don't want people to be putting personal information on there and then it kind of just gets, onto the internet forever. And obviously this isn't legal advice as well. So it's just me and Will tonight. Shannon's doing some very cool stuff, which I don't think I genuinely can actually talk about. It's some very cool stuff with using her experience to get some policy stuff changed. So I hope she's has some luck in the next couple of days with that. Just sort my screen a little bit. So we've got several questions coming in through the course of the week, and we've got some questions already on the live chat. Will, because the questions on the live chat are quite straightforward-ish, can we start with them? And just because I know I'm aware that some people might be waiting around for 45 minutes with that, just wait for that. So the first one is just basically sounds like we've got a dad here who's sharing accommodation with a 16-year-old daughter, and the question is she can't stay here anymore. My guess is there's been some sort of relationship breakdown or something. There may be some issues around, I don't know, her behaviour is kind of not unusual for that kind of situation. The question is, has the council got an obligation to help her? So the answer is potentially, if she is homeless, as in it's not reasonable for her to continue to remain there, then she would initially, she should be forwarded on to Children's Services, who should do a Children Act assessment. But should she refuse that support under the Children Act, which some people, some children don't want it, then she would automatically be in priority need should she make a homeless application. So the first thing to say is that she should absolutely approach the council, whether it's Children's Services or housing, and they should, what they shouldn't do is just kind of juggle between the two. But what certainly, I don't know what Children's Services would do actually, but housing, their first job would be to ensure that actually it genuinely isn't possible for her to continue living there. Because this is one of the, kind of for a long time, for decades, there's been this issue where parents realised if they kick their kid out at that sort of age range, it will be a fast track way of getting them housed. And so councils, have to be mindful of that generally. And so they'll want to probably speak to the parents and actually check that's not, the arrangements can't continue. So I've got a bit more to say about that, but Will, do you want to come in and say anything about any of that?
Yeah, I haven't got much to add to that. I think you covered everything. I think she would have to go through Children's Services to start with, because I think that people who are children in need, which she would be, are excluded from, they're not eligible under Part 7. I haven't come across a situation where somebody refuses it and then by default is entitled to.
I think the issue is that essentially sometimes they're not given the full information. But I mean, I'm aware of cases where the child might have already had contact with Children's Services and quite frankly doesn't want a social worker.
Well, that's very common.
Yeah, so and this is something which I was unaware of for years actually. So in one sense, I always said that 16, 17-year-olds are automatically in priority need, which is technically true, but they have to have gone through the Children Act process first, which is what I didn't realise up until not too long ago. And again, with this kind of, I guess, a little bit extra on this, in your area, you probably have services like the YMCA, those kind of like, younger people, homeless charities, which would also have some options for them. One thing to make sure is that any child in that situation is really made aware of their circumstances, because certainly my experience in, locally is that they'll just get kind of herded into supported accommodation without actually the option of having their own, kind of going down and making a homeless application and potentially being housed as a result of it. So that's kind of something just to ensure, because some people, get on the right with YMCA and some people don't. And ultimately they have a right to kind of, to at least kind of try out that route. So they should be able to, or there should be help to do that. So hopefully that's helpful. As I say, it's a difficult situation housing officers are in when they have that conversation, because they obviously don't have the housing stock. So they kind of, it's very difficult. It's already a very difficult situation for them. Plus they've got this pressure to not house people. So that conversation with the parent can get pretty fraught. And I've seen housing officers basically lie and say, well, you know, if you don't house them, then they're going to be street homeless, which is not true. But you can't, you know, I sympathise with housing officers more than in most situations in this situation. So I think that's something, yeah. So I think that covers it. There's nothing else I want to say about that.
Yeah,
So
I think I should just correct myself. And you were right, Mike, because I'm looking at the shelter website about 16 or 17-year-olds, and it says that they're in priority need if they're not looked after by social services. My understanding is that they should be looked after by social services. So, but if they're not, I guess it's that situation where somebody is street homeless and they go to their homeless persons unit and they say, we can't help you because you're 16 or 17, you should be getting housed by children's services, but because you're not, we're not going to give you anything either. They should be saying, yeah, we'll give you something.
Yeah.
So sorry, yeah, that's fine.
It's definitely a situation where both departments should be helpful, but in reality, often neither are. So again, if you're a professional working with a kid in that situation, then I would suggest strongly you go through and make a robust complaint about it. But yeah, hopefully that's helpful. There's a comment there just saying that a previous discussion we had in a previous live stream about mental capacity and that kind of stuff has been very helpful because this person's now been housed in temporary accommodation. So that's cool. Good to hear. And then there's a question there about what's the general timescale of the decision of a Section 213 referral application? Now, I am a little bit confused by this question because the only referral I know of within Part 7 of the Housing Act is 198, Section 198, where someone makes a homeless application, there's reason to believe they might be homeless, the application's received, and then they establish that actually they don't have local connections to that local authority, so they'll look to refer them back under Section 198 to the local authority where it's safe to be, where the person does have a connection. There's more to it than that, because I always say in the training we do, the Section 188, in terms of the duty to provide interim temporary accommodation, it basically doesn't include the assessment of local connection. It's only whether there's reason to believe you might be homeless, might be eligible, might be in priority needs. The local connection kind of stuff comes afterwards, and technically speaking, it doesn't have to come at all. It's just down to the local authority whether they do it or not. But because everyone's strapped for housing, they will. And this is something which is really annoying as well. Just sorry, I'm not padding. I'm trying to just give a bit of context for this. But basically, before the HRA came in, local connection was basically the last thing a council would look at, but now councils can look at local connection much sooner in the process. So once they've kind of looked at that Section 188 stuff, they can then essentially immediately start that work of, do you have a local connection here? And if not, where do you have a local connection? And if you have a local connection somewhere else, is it safe for you to return there? Now, in answering the question, if it is the question, I think it is in terms of the timescale of a Section 198 referral, and with local connection criteria. I need to. I read this not too long ago. I can't remember where I read it, but it was kind of like it's sort of subsidiary guidance to this kind of stuff. And I think it was something like 7 or 10 days. So they make a referral, and the receiving authority has something like 7 or 10 days to pick up the referral. But again, I've just kind of briefly had to look in my documents. I can't find where I read it, but it's something like that anyway. So yeah, Will, do you know anything? I mean, first of all, is there another thing that we might be have we got the question wrong there? Is it actually about something else, do we think?
Well, I've been looking up on I've made it to the City of Westminster website, and they're talking about the duty to refer under Section 213B, which says that where specified public bodies are required to notify a housing authority of service users they consider may be homeless. I assume that's what we're talking about here.
Okay, right, yeah. Ignore everything I just said then. So we're talking about the duty to refer rather than referral.
Yeah, unless are you talking about a referral where they haven't got local connection with the first authority? Yeah.
So okay, so the duty to refer then. I don't know the straight answer to this either, actually, but in my experience, it's as far as I know, it's basically immediate. The council has to pick it up or do something with it immediately. But just again, just to kind of labour the point, the duty to refer does not trigger a homeless application. So what can happen is the duty to refer form is submitted. There's a phone number on it. The housing officer tries to ring the phone number once, doesn't get through. Okay, back to the bottom of the pile. Whereas a homeless application, gives the council reasons to believe you might be homeless, but crucially it asks the council for help with housing, which is what the duty to refer doesn't do, then you're in a much more robust situation where the council has to act. It can't just shrug off and say, well, we didn't get hold of you once. They would have to, they'd have to make a significant effort to actually look into it. So sorry that I completely misunderstood the question to start off with, but yeah, hopefully we'll get somewhere in a minute.
I think the answer to this question is that there isn't a set time limit. I think for most of these sorts of things, it has to be within a reasonable time. So it depends on the circumstances. If there was a terrible crisis and the council weren't doing anything, it might be that somebody could run off to the High Court and get an order quite quickly saying you should act on this. Whereas if it's not urgent, then it would be more difficult to do that. What I'll do is I'm happy to, maybe we should have this as a regular feature where we can say, that's a very tricky question. What we'll do is if you tune in next week, we will have
a better answer
to it by then.
Yeah.
I don't know what you think, Mike, but would it be helpful if when people post questions, I'm not asking them to disclose things about themselves or personal stuff, but if they could go into a tiny bit more detail about what it is they mean, like the question we were just talking about with the daughter, that was very, very minimal. I wasn't quite sure. What the 213 referral's about. I appreciate that may lead people to going into more detail than they want to, but if they could say a referral is made by authority A because of this or that, then it would make more sense, because it's quite difficult to answer them.
I think that the difficulty people have is that you don't always know what's actually relevant. I think that's a problem. Because you're like, well, where do we start? So I think another thing kind of with the duty to refer is that, so say it's a prison, for example. So prison, someone's within 56 days of their release date, it's likely they're going to be homeless on release. They make a duty to refer at that point. As you say, Will, there's no urgency at that point really, because that person's got another 55 days left or whatever on that timer. So most councils, it seems at the moment, are literally leaving everything to the last minute, if not beyond it.
They've always done that, haven't they? It used to be the sort of mantra was come and see us on the day you get evicted, when you're actually homeless, by which time you've got your children and your belongings with you, and it's an impossible thing to go and sit in the waiting room, which I think the Homelessness Reduction Act does reduce that. So if you're threatened with homelessness within 28 days, but yeah, there's a danger to leave everything to the last minute.
And I think as well, so I guess, I think we'll roll this question on for sure, but my assumption would be is if somebody is homeless, then it needs to be picked up immediately. And it goes back to that kind of thing of, well, if you're a professional supporting an individual, why would you not make a homeless application as well? I appreciate some organisations have a duty to refer, so fill the form in, no problem, if you're probation or prison or whatever. But once you've done that, send another email saying this is a homeless application. Joe Bloggs is homeless tonight and he wants your help. Section 184 is now triggered, and then you provide some additional information around priority need or anything you've got around eligibility, just to hopefully hit that section 188 threshold. So I think, well, let's roll that question on for sure, because it might be that it says it's some specific somewhere in the code of guidance, but it's not something I'm aware of there being. And again, apologies that I got the wrong end of the stick to start off with that one. So got a question which I think actually is, so we've got two questions to ask from the week, and I'll start with, so I've sent them over to you, Will. Let's start with the first one. So this is the situation. I think it's actually the same question that's been asked in the chat, so I think it might be the same person. But so we've got a single male, he's aged 36 and he's in private rented accommodation. And the private rented accommodation is £700 a month, which covers rent, water and council tax. Which, as an aside, is a bit of an interesting one that maybe makes me think it might be a HMO, although that's a lot of money for a HMO where you've got, your utilities are included in the bill. But anyway, so he got made redundant 4 years ago. He sold all his possessions. He's on universal credit, £300 a month, and he gets 350 quid towards rent. About 2 months ago, he was given Section 21. The council housing looked into this and said it was not valid due to electrical gas certificates. I then told them, this is good work here, I then told them that he physically cannot afford to pay, and so technically he's homeless, and they requested an income and expenditure, which we did, showing he can't afford it. And now they've said that because he's got a debt of £1,000 from on a property 10 years ago, which he didn't know about until now. They've said they can't help him. So that's a really good bit of support work there in terms of, the council's kind of said, well, you're not threatened with homelessness yet because the notice isn't valid. But the issue actually is, no, he can't afford his rent, so he's already legally homeless through the unreasonable to continue to occupy section of Section 175. So that's kind of good. But what comes next with the council, what they're saying, I think is nonsense. I think, in one sense, there is no situation in which debt from 10 years ago would have any impact at all on those initial homelessness duties. And it doesn't seem like there's any kind of link between, so it's not even that it's about intentional homelessness or something. I think what the DHP, I don't know, I may be speculating, maybe the DHP team's got some stupid policy in there about, if someone's got arrears, then we won't help them or something. But I've got no idea why that would be being said. However, my first answer to this would be, well, request a copy of the DHP policy that says that they can't help because of this historic arrears. And if they don't give it to you, FOI it and get it through the Freedom of Information process, and then just see what it actually says. Because my guess here is that the officer dealing with this request has simply got the wrong end of the stick or doesn't understand their own policy. I can't see any way that would be a thing. And again, if you're a professional and you're supporting someone in this situation and you need a rapid response, then again, if it was me, I'd be very quick to complain about it just to get it raised as an issue, because otherwise you're just kind of waiting for weeks before you get a response, whereas a complaint, you will generally get a much quicker response by doing it. And there's other stuff that came in the question just saying how much it is impacting their mental health and stuff, which is understandable. But in one sense, that doesn't affect it. So yeah, that's my take on it. And I think the other thing that's interesting here is that, these figures of £700 a month, but you're only getting 350 towards rent. That says to me that maybe he's been treated as an under 35 or something, because that's a low amount of money to get. Obviously it depends on the council. You'd need to look at your local council's local housing allowance to see how much he's eligible for. But that seems to me to be a low amount. And I'm almost kind of thinking, well, has he kind of snuck through and have they not picked up on the fact he's now 35, he's now eligible for more money? I don't know. So that's something I noticed.
I mean, maybe the 700 is shorthand for the housing expenses, because I may be a bit rusty, but if council tax, if you're on universal credit, you should be immune, or in the old days, it'd be council tax benefits, so you wouldn't be liable to pay council tax. But has that changed?
So that all I know is that depends on the council. So some councils provide like 100% discount. So yeah, council tax benefit, you get it all paid. But a lot of councils, I think, they certainly won't pay the full amount. They might pay a percentage of it.
Okay.
So I think again, that might be down to the council.
But the bottom line with this one is that the advice that they're getting about the £1,000 is nonsense. Because if they're saying, the conversation goes like this, he's homeless because he can't afford the rent, and they say, well, he owed some money from 10 years ago or 10 years ago, which has nothing to do with it's a different issue. I mean, maybe 10 years ago he had a different problem, but it wouldn't be a reason, because you'd think, well, the only relevance it would have to the homeless would be whether you're somehow intentionally homeless because of that. And obviously you're not, because you can't afford the rent at the moment. So it's got to be accommodation that was reasonable for you to continue to occupy. And
just to labour the point, on the face of those facts as well, the reason for him now being in unaffordable accommodation is the loss of his job. So it's not, it's not that, it doesn't seem any way that 10-year-old rent, that debt would kind of have any way of coming back in terms of current intentional homelessness. It might be that he punched his boss in the face and he lost his job because of that. Well, okay, now he might be intentionally homeless, but it's not anything to do with that debt.
The other thing you sometimes get, and you get people talking at cross purposes, is that when you're talking about housing allocation schemes, it is quite common. Well, I've heard of it happening where you can be excluded from the housing register if you have rent arrears of more than a certain amount. And I had one the other day where they said, oh, we tried to put her in a higher band, but we couldn't because she had £500 rent arrears. So I then got a rent statement which showed she didn't have any rent arrears. So I sent that to them, and they said, "Oh yeah, that's right, but oh dear, she turned down an offer of suitable temporary accommodation, so we're not going to house her anyway." But that struck me as quite harsh, that rent arrears bit. But that could be what they're talking to here.
It might almost be that it might be they've almost got like, the DHP team's got their own policy which hasn't got anything to do with the law, and they're just applying that when actually, they can't just apply, they can't use it in that situation. But I think my guess is it's just the officer who's dealing or giving that response has misunderstood what the rules are.
I think it's just also there's a sort of compulsion amongst, forgive me, housing officers out there who may be watching it, or there's a compulsion to take a negative stance. Like, I was just on a slightly separate subject. I was talking today to somebody from a local authority about somebody who's at risk of domestic violence. And I said to her, it's quite serious domestic violence, this. I mean, not that any of it isn't serious, but this was like somebody getting their door kicked in and sort of really heavy levels of violence. And I got asked the question, well, has she contacted any women's organisations? And I said no, and I don't think she's under any obligation to. And I think the woman who I was talking to knew that. I mean, she wasn't seriously suggesting it, but she couldn't help just, because the implication was, oh, well, I'm not so sure it's serious. If it was serious risk, I don't quite know what women's organisations are supposed to do to help with the. I mean, I suppose put her in a refuge is the what she's thinking of. But I just thought it showed us sort of the wheels in the mind were turning. Sort of, I've got to listen to what the person says and then think of something negative. And that sort of sounds like this. Oh, rent arrears. That sounds like intentional homelessness. You're in trouble. But
I think that's a really nice way of putting it professionally. Like, if an officer comes back and says, well, what about this? So, well, they haven't got a legal obligation to do that. So let's just put that to one side.
I added to that. I said, she hasn't got a legal obligation to do that, but you've got a legal obligation to make inquiries and provide temporary accommodation, which don't you? And she said, yeah, I do. All right, I do.
Well played.
But actually, there's a happy ending. They've said to her they're going to give her somewhere temporary. So, I mean, they're all right. I mean, the woman was very nice, and she rang me back within about 3 working hours of me getting in touch. So full marks there.
Yeah, fair enough. Yeah, I mean, I think I think our line is that we sympathise with most housing officers, but not all of them. And
it's just like everyone's got their little foibles. Like, solicitors have a tendency to use silly words where they could just use simple words, but they, if they get nervous, they start saying, I'm perplexed by this rather than I'm confused. And it's sort of like, people leave me alone if I talk like a judge.
Cool. Okay. So hopefully, hopefully that answers the question that kind of covers that. I mean, maybe there might be possible to give some more detail. Yeah, that's all right. So it might be some more detail that just help us if we've gone off on the wrong kind of tangent there. And just I mean, so interestingly, so I was delivering training on Monday, and Will, we've got some regulars. So one of the guys in the training said that he always listens to this on Friday morning when he goes to work. So, and this question's from him, so I'll come back to that in a minute. A little bit as well. Just remembered, as always with YouTube, just please do the whole like and subscribe thing just to support us if you find stuff useful. And if you've got any kind of questions kind of that aren't in the live stream, put them into the comments section anonymously, or about someone else, and I'll try and pick up on any questions that are straightforward to answer. And no, we haven't got capacity to help you out, unfortunately, like kind of one-to-one. It's just we do this stuff to kind of share the information as widely as we can. So right, the question is coming from our regular. So big shout out to Peter out there. I'm pretty sure I'm comfortable saying his name. So, and it's quite a long one, but it's a really good one to kind of get our teeth into. So we've got a mum, and her mum's got a disabled daughter who's turned 18 whilst in temporary accommodation. Now, I'm not sure yet whether that detail's relevant, but it might be. So it's helpful to have that in the question. So they're homeless following a Section 21 notice. So it's no fault eviction. And the daughter has mobility issues, learning difficulties, and sensory issues. And the mother has ADHD. So they're in temporary accommodation, and then the council accepted a full housing duty. So Section 193 kicks in, and the original temporary accommodation property was Victorian terrace with very steep stairs, and both the pair were able to manage this by going up and down the stairs on their bottom. So I might be misunderstanding it. The daughter's definitely got mobility issues. I'm not sure about the mum, but either way, maybe the mum's helping the daughter up the stairs. And they didn't raise this with housing, so for whatever reason they didn't tell the council. But at some point, one of them stumbled on the stairs and hurt themselves. So social services were involved with the daughter, and then the social worker, in the words of the question, took it upon themselves to contact housing and say the client's current accommodation was unsuitable, which is I think a good thing to do. It's just sometimes you have some inadvertent negative consequences, as we'll see in a minute. So then the client received a call the day before the daughter's 18th birthday to say it was her last night in the TA. She was told she needed to be at the council offices the following day to sign a new agreement to a new property. She raised that she couldn't be possible. It's not possible to move all her belongings in this time. And the council said it was not something the council could help her with. Interesting, because I know which council this is about, and they appear to have a policy where they do not help people protect their property, which I would imagine the LJO is going to come and have a finding about that fairly soon. The following day, she signed the agreement. Wording above the signature gave consequences of possible refusal. So she's told very clearly, if you don't accept this offer, then we'll potentially discharge our duty or end our duty to house you. She said she felt rushed and signing this, and was laughed at by a member of staff while in the council offices. The client states it was a traumatic experience, which, speaking to lots of people who've been homeless, I would say these things do actually seem to have traumatic effects. Client viewed the property. Property smelled of smoke, urine. She felt she could not put her daughter in it, particularly because of the daughter's breathing issues. So they called the temporary accommodation team, informed that she couldn't occupy the property, and then they received a notification that the Section 193 duty had been brought to an end because of refusal of the temporary accommodation. Client has been told that negative impact the application to the housing register. So effectively, it sounds like, that has a knock-on effect to mean that she's either kind of downgraded on the housing register, or potentially she's kind of removed from the register altogether. The made a subject access request could work, and a Section 202 review has been requested. And the request basically says that they've kind of requested temporary accommodation pending the outcome of the review, and it's that's been agreed. So there's a whole lot of good stuff, of interesting stuff in here, by the way, nearly at the end. So now client needs help with finding grounds for the 202 challenge. So they've asked for a review, but you can still put additional points in after that initial letter goes in. And the thing that this individual or the professional's looking at, was the client's ADHD explored in the PHP, so the personalised housing plan, whether it would be appropriate to conduct by the LA, the local authority, considering public sector equality duty. I guess the question here is, if her ADHD impacted on her ability to take in information in a short space of time, that might be relevant. But what's also going to be necessary there is that it's important that she would have told the council that that's the case. So with disabilities, it's really important you tell the council that you've got a disability, and crucially, you need to tell the council what they need to do in response to that. So if you said, I have ADHD, I struggle to take in information in a short space of time, can you ensure that I've got adequate time to make decisions? Can you ensure that it's written nice and clear, that I'm not put under pressure, unnecessarily, all those kind of things you'd want to put in. So that's the first point this guy said. So evidencing the impact and speed of the move would have on the client and daughter's mental health. So again, that's kind of saying, well, you're told you've got to move tomorrow. You've got a million things to worry about. Are you going to read the small print of a form you sign? And that's, unfortunately, I think the answer is, anything you sign, you've got to have read. So again, it's a difficult one, I think. So smoke and asthma, in terms of the smoky house and asthma, would that affect suitability? And finally, was the client actually helped to understand the consequences of refusal as opposed to being rushed through signing the agreement? She was unaware the LA could end the duty as a consequence. So she's basically saying, yeah, I signed it, but I didn't read it, and I certainly didn't understand it. So that's the situation. As I say, I think it's worth going into a lot of detail in this, because it's got a lot of elements which are pretty common to people's situations. So yeah, you've got someone, they've basically refused what the council deemed to be suitable temporary accommodation. And just to kind of say some obvious stuff as well, it sounds like this household is obviously going to be in priority needs because of the daughter's disabilities. So that's, that might become relevant down the line. And a few bits of interesting things. So this guy's done a good bit of work, because when you make a review request, so when you challenge that Section 184 decision, if you want temporary accommodation, you've got to ask for it. That's the first thing. So you specifically have to say, can I have accommodation whilst this review is ongoing? And the second thing is you've got to provide some information that's more than trivial that was not included in that original decision, which is not difficult because most decisions don't actually have a lot of information in them. But you need to have those two criteria, and then the council should continue to provide you temporary accommodation pending the outcome of the review. So that's the situation. Will, what are your initial thoughts?
I was just looking because I wanted to quote chapter and verse, but just going back to that last point, I think it's the case, isn't it, that they can't refuse temporary accommodation pending a review if the review is of the suitability of accommodation.
Say that again.
The council has to continue to provide temporary accommodation where somebody is challenging a decision that the duties are discharged because of the refusal of an offer of accommodation. And I was just looking because I think that was brought in as a change by the 2017 Act, sorry.
I'm not following yet.
Yeah, here we go. For the purposes of this section, this is section 188. For the purpose of this section, where the applicant requests a review under section 202 of the authority's decision as to the suitability of the accommodation offered to the applicant, by way of a final offer. So if this was alternative temporary, they may not.
Yeah.
But
yeah.
It's a good sign. It's interesting because I find it's quite common that a local authority will say, no, we're not going to give you temporary because...
So sorry, that what you just said, I still don't understand it, but it sounded important. So
yes.
I think this is all under section 103. So in one sense, the main duty has been accepted. It's just a different temporary accommodation unit. But no, you're right. Yeah. So you're right. But so if it was just section 188 accommodation, what would the implications be in terms of asking for a review and being accommodated pending the outcome of the review?
Goes back to what's known as the what we in the trade call the Mohammed criteria, which is an unfortunate term, but it means in this context, it relates to a case called Mohammed, where the council, where you can't just say, can I have some temporary accommodation because I'm requesting a review, because they'll say, well, you haven't asked us properly. It's a bit silly because you have to say, I believe I have a good prospect of success, plus that I would suffer if I became homeless. And therefore, if you weigh up those things, then you should exercise your discretion to house me, which is a bit daft because they've accepted that you're in priority need before they make you the offer. So you're going to suffer. And obviously you think you've got good grounds for requesting a review, otherwise you wouldn't have done it.
That's because I remember challenging a letter that was basic, and the wording, the council's wording was, we don't think this has got a reasonable prospect of, and that was, so that's obviously what they were actually referring to there, as they're saying you don't meet that criteria.
Yeah. So I have 3 letters that I use whenever I do this. One is called these are templates that I fill out. One is the one where I make the representations in support of the review. So I can tell you what I'd say in this case in a moment. The second is a letter that says, further to my first letter, I'm writing to ask that you give temporary accommodation. And most of that is standard text that you've just changed the name. And then the third one is a letter in accordance with the Judicial Review Pre-Action Protocol saying, I've asked you to exercise your discretion. I believe you should do. And if you don't, there's going to be trouble for the client. So I'm giving you X amount of time to agree. Otherwise, we go for judicial review. And that's normally, if I don't take those steps, if I just wrote to them and said, can we have temporary accommodation, please? We've got a good case and, we're in priority need. They'd probably say, no, that's not good enough. And they'd quote the case to me. Can I go back and just say a couple of things about the actual Routes 202 challenge?
Before you do, so that you're reading a bit of the Code of Guidance. What bit were you reading? Because it was a bit...
I wasn't. I was reading actually the Housing Act 1996 on the government website.
Which section? Section
188.
Yeah.
If you look, and this is the as amended, so it includes the amendments, and I think 2A. If you go down to section 1882A.
Yep.
It's the one that starts about for the purposes of this section where they request a review under 2021H of the authority's decision as to the suitability of accommodation as a
Okay.
final offer.
Yeah. Okay. Yes, I'll probably come back to that because anytime I read the Housing Act, I'll have to read it about 10 times to make sense of it.
Yes, but we're assuming for the sake of this conversation that, and I think correctly, that this offer is just alternative temporary.
Yeah. So
Yes.
yeah, they're saying it's more suitable. I guess another thing to say at this. No, I'll save that for in a minute. So yeah, keep going. So what would be your sort of standard response to the situation?
Well, if you think about it's saying that they're saying that she's refused the offer, yeah. But the scenario is that she's actually signed the agreement under pressure. So it's arguable that she hasn't refused the offer. What she's actually done is accepted the offer, gone to view it and said, this is unsuitable, I can't live here, which isn't necessarily the same as refusing it, because she's accepted it. They could say, well, if you don't move in, we're going to give you 7 days. We think it's suitable. Stop messing around. We're going to treat this as a refusal. But arguably, I think she's got an argument to say, well, I didn't refuse it, full stop. I accepted it. You made me come in yesterday and I did that. What I did was I alerted you to my concerns about suitability, which prevented me from staying there. But that's not the same as refusing it.
There's a bit which that just kind of made me think of. So because someone asked me not too long ago, like at what point is someone not following rules or like abandoning TA? At what point is that can that be considered actual refusal? And I'm trying to just keep going because I'm trying to dig out the bit I got back to because I did a bit of reading and found a useful bit. So yeah, so sorry, keep going. Well, sorry, just that's not helpful for me.
I mean, I guess it's another one where I hate to sort of come out with a set expression again, but it's a sort of reasonable time, isn't it? Because it's not going to be sort of, if you're not there within a number of hours of signing the agreement and sort of reporting for duty, as it were, they'll treat you as refusing. But at the same time, if you never turn up and a month goes by, they might conclude that you're not living there and you're living somewhere else. So I would say, I mean, I've got a case that I've been fighting with the council, and they reluctantly gave temporary accommodation earlier this week. And they seem to have formed the impression that the client wasn't there, but she says she was there. But they were writing to me saying, this can't go on indefinitely. But I said to them, I think she's actually there, and I think they've accepted that. But I think if she'd left it much longer, they would have refused to extend it. And the problem you've got is, of course, with temporary accommodation, if it's Section 188 accommodation, and even worse if it's a hostel or bed and breakfast accommodation, you've got no security there. So if they decide that you're not there, they can just say, well, we've terminated it. And then you're sort of stuck. And it's very harsh. I mean, you'd have to go back and apply again, and then they'd find you intentionally homeless. And you could challenge that.
So it's an interesting kind of line you're saying. So in one sense, she's not explicitly refused it. They're saying that, so then they're effectively saying, well, you've implicitly refused it. Now, there's a bit in Jan Luber's textbook, I just dug it out, which is Jan Luber's Housing Allocation Homelessness, it's called. It's really expensive, but it's the best book out there probably. And so there's a section there, it's called implied refusal. So it's paragraph 16.62.
Right.
So an applicant's behaviour in the accommodation could be construed as manifesting an implied rejection of the accommodation. So if they break rules and so on. Local authorities should be cautious about deciding that an applicant has rejected the accommodation before deciding their initial accommodation duties come to an end. So I know it's talking about Section 188 here, but it's probably the same principle. One local housing authority was subject to judicial review proceedings when it refused to secure further interim accommodation, insisting the applicant had rejected the accommodation after the applicant had arrived at the accommodation a day late. And it goes on, it's basically saying, they need to kind of have done their workings out. They need to have done their homework to say, we've given them reasonable, I think there's a bit more actually. The local housing authority should normally give the applicant a warning and an opportunity to provide an explanation for their conduct. So that's talking about behaviour, but I'd say the same thing. If they've explicitly accepted it and then they haven't moved in, then the local authority would need to contact them again and say,
But there could be any number of reasons for that. They could have had an accident or something.
Yeah.
So as in that case, I mean, the person would have to, if they turned up late, they'd have to say, we think, is the reason you're late because you're rejecting this? Well, if you look at it another way, if the person says, if she called them up and said, I know I signed this yesterday, but you can treat this from now on, I'm not taking this, I'm never setting foot in here again, then they could say, well, you accepted it, but you gave it up. But here, if she says, I mean, she has said she felt she couldn't put her disabled daughter in it, but that's not necessarily the same as saying, well, you can shove this, but she's saying this isn't suitable, can you give me something else? Which is a different conversation.
So I think kind of going outside the legal world here, there'd be two things I'd be recommending here as well. So one would be getting photographic documentary evidence of it. I've given the example before about a single mum I work with who took a recording of the TA, tried to get the council to fix the issues. They didn't, so she put it on YouTube and basically said, unless you fix this within 24 hours, I'm going to go and put this on the We Are Bedford site. And it was a very effective way of getting a very quick outcome. So that would be something I'd probably suggest. And also, ultimately, I know this has already happened, but if you're a professional supporting someone in the situation, then rejecting the accommodation is making your life more difficult. It's probably fair to say. So it may well be you're right. It may well be the accommodation genuinely isn't suitable, but it's always sensible to accept it and then kind of challenge the suitability, because it's much more. You're playing chicken with a local authority if you do it the other way around and reject it, and then hope that you kind of win the argument with them.
Yeah.
Okay.
There's another slight legalistic point which barristers have made to me, and I never quite get my head around this with refusals. But in a way, there has to be a sort of two-stage process before the council can treat its duties as discharged. The first one is to say, we've thought about this and we think this is suitable for you. And the second is to say, you've unreasonably refused it. And those, if they haven't done both of those, arguably they haven't discharged their duties. I won't go into that in too much more detail unless you want me to try, but it's worth looking at that to say, well, you haven't actually told us you think it's suitable. We've raised concerns. If you said, no, we've looked into this, and we think we've sent somebody around there isn't any smell of smoke or urine, so we're giving you a chance to reconsider, we think it's suitable, then I think they could say. So I would stick that into the representations.
And I've got a couple more things to say, actually. So one is that also get involved your ward councillor, because this situation, most human beings will have a lot of sympathy for you, basically. So getting a ward councillor in there to kind of be on your side is going to be useful. The other thing to say is that I know which council this is. I've had contact with them before, and they are not used to being challenged robustly at all. I did an FOI, their Freedom of Information request there, and asked them what training they got about the Housing Act 1996. And the response was, we don't use the Housing Act 1996, we use the Housing Act 2002, 2004. And they was like, what? I'm like, yes. So they as many local authorities are out in the sticks, they are not used to being challenged robustly. So the argument that you just said there, Will, in terms of, did you kind of have this two-stage process, all those kind of things, they probably just don't know that they're supposed to do that. So I think it's well worth challenging that and kind of going down that line. I think there's a lot of different things that would potentially help.
Then I would confirm, I agree with you that anything to do with the ADHD and disability and things not being explained should be thrown in, because then you can say there wasn't actually a decision. Everything happened so quickly that this person, you didn't consider that somebody with ADHD may have had difficulty engaging with that.
Just a question, and that's a bit of it's a big tangent. What's your experience, Will, in terms of supporting someone to be shown to be in priority need where their only diagnosis is ADHD? Because I've not seen. I mean, I don't know that much about ADHD. It seems to be something which people doesn't generally get treated seriously by the council. I'm not even sure. I mean, this is probably a good example where taking in information is made more difficult. But have you ever seen a case?
I've never had a case where it just turned on ADHD. But all I can say is that it's always worth asking yourself the questions, what would happen as a result of this person's ADHD, for instance, if they became street homeless? And there's two questions, two different tiers. Number one is, would they suffer harm or injury as a result of that condition, which an able-bodied person wouldn't suffer from? And that could even be a deterioration in their condition. It doesn't have to be that they would sort of fall off a cliff or something because of that condition. It could just be that they feel worse, their ADHD gets worse. And the second is, and this may be more relevant, is would they have more difficulty coping with the consequences of homelessness? And so would they find it more difficult to access accommodation? And I don't know, I'm not an expert on ADHD, but one should never underestimate a condition. And the council will tend to do that. And they'll I think I haven't mentioned now medical yet, so it's probably overdue, but the council will generally ask now medical a question, and they'll say ADHD, what a lot of nonsense. That's not really a serious condition. But it's the same if you think about it with depression. Depression is a condition which is particularly relevant to things like people getting evicted, because you go to court and say, look, I just can't cope with all these letters coming through the door. I stash them all next to the front door. They never get opened. And so now I've got rent arrears. And there's a tendency to say, oh, depression, that's not a proper medical condition. That's just how you feel if things aren't going right. But that's a complete mistake, because obviously depression, it could start off as being a healthy response to an unfortunate situation, which isn't an illness. But then again, it takes on a life of its own after a bit, and it can become an illness which is highly debilitating. So I would say the same thing with ADHD. Just because it's not something that you hear about on the news that people are suffering from serious consequences, it doesn't mean that if they were street homeless, they wouldn't. So that's a very long answer to your question, which perhaps I should have just said I haven't actually dealt with.
No, that's a really helpful response, actually. Because it's good. It's also good to. My opinion is you can't underestimate how low that threshold is on priority needs. Because I think I saw this in a Facebook group, not our one, but a different one, and someone had asked about vulnerability, and the response they got from one of the admin, I think it was an admin, basically said, you're in priority need if you're exceptionally more vulnerable than the ordinary help.
Yeah.
And it's like, housing officers just insert these words and just kind of just bump up the thresholds.
You see, even putting that word in a decision letter would mean that they would lose, because in the case of Paniotu, which is the big deciding case, there were actually two cases in that one. They were joined together in the Court of Appeal. One was called Smith and one was called Paniotu. And in Paniotu lost, and they said no, the decision was okay. And in Smith, the decision was unlawful. And the difference, they were almost identical. The difference was that the reviewing officer in Smith had used the wording, you are not significantly more vulnerable than a vulnerable person, or something like that. It was turned just on the wording.
Yeah.
So they've got to be really careful.
Yeah. Cool. Okay. Just last few thoughts on that question. So in terms of making the review based on the smoke and asthma, then you should be seeking out medical assessments and medical evidence of how bad the asthma is, and ultimately would it be affected by a property which no one's smoking in it now but has been smoked in before. When I moved, my missus has got asthma, and when we moved house, this guy must have been an absolute chain smoker. I spent a week cleaning off the tobacco off the ceiling. It's horrible. It's like dripping down on me and stuff like that. But she just by staying in that house for a night, she was just having asthma attacks. So I think it would depend on how bad the asthma is and how bad the smoke damage or smoke is in the property. Probably kind of boost to kind of make that argument.
And asthma is a much more serious thing. I mean, going back to the ADHD thing, asthma can actually kill people. You can have a fatal asthma attack. Yeah.
Okay. I think that's you've kind of given me some answers there that were what I wasn't expecting. So that's really helpful. So hopefully that's helpful for everyone else. Cool. Okay. Next one, there's a couple of questions in the live chat. How are we doing for time? We're doing all right for time. We've got 10 minutes.
Yeah.
So can someone get housed under Section 21? So this is another one where we're not. This is it's difficult to kind of understand the jargon with when you're not in the sector. But so Section 21 is really if someone talks about housing in Section 21, they're talking about an eviction notice where it's effectively a no-fault eviction kind of. That's what it kind of gets called colloquially. And that's if the eviction notice is valid and you're within 56 days of it expiring, you can make a homeless application and the prevention duty would kick in. But that in itself is not enough for the council to have a duty to actually house you. They would have a duty to do a personalised housing plan with you, to give you advice and assistance, to take reasonable steps to try to to help you get alternative accommodation. But basically the housing duty. So this is, I guess, a little bit of jargon that's helpful to know. This is how I call them anyway. So you might say actually that you use different words, but there's various duties under the Housing Act, and specifically there are housing duties. So the advice and assistance duty. So councils have to give advice and assistance to everyone in their district, basically, irrespective of whether they are eligible for assistance, whether they've got recourse to public funds, and so on. But there are certain duties within the Housing Act which are housing duties, as in Section 188, whether they've got a duty to put you in interim accommodation. Section 191, duties to people who are in priority need but intentionally homeless. So that's where they've got to provide you with accommodation for a period of time that gives you a reasonable prospect of finding something else. And then Section 193, and there's probably some other ones as well in there as well. But they're the housing duties, but there are other duties like protecting your property. Those are the kind of things which aren't housing duties, but they're duties under the Housing Act. So hopefully that just kind of makes sense. But yeah, so housing duties, those duties to provide you accommodation basically hinge on you being in priority need, or at least there being reason to believe you might be in priority needs. So lots of people get Section 21 notices and they won't be in priority needs. There won't be any reason to think they even might be in priority needs. The council will have to go through those other steps, personalised housing plan, take reasonable steps to get you accommodated, blah, blah, blah. But it doesn't extend to actually putting a roof over your head. So yeah, so in one sense, it's not a silly question, but it's like actually the question is, is there a duty to people who are not in priority need? The answer is there's no duty to put a roof over your head. They can help you find somewhere. There are things they can still do. So it's still absolutely in your interest to go to a council. It should be the default position of every homeless person to make a homeless application. But it's not necessarily going to result in anything useful, like in terms of actually a roof. Anything you want to say on that? Will, there's another one as well.
So just very quickly, my understanding there, that's a question about Section 21 of the Housing Act 1988. So the notice of terminating the short hold, yeah? So
yeah, I don't know any other Section 21s that would be relevant. Yeah.
So that wouldn't give rise to, you wouldn't get housing under that, but you might get housed because of that. So maybe that's the same thing. The thing I would say is, and this comes back to what we've talked about before, and with the relief duty. So that if you didn't have priority needs and you went in and you'd been given a Section 21 notice, you would be entitled to be treated as homeless or threatened with homelessness pursuant to that once it expires. And then the question is, well, if you're not in priority need, you're right, you're in a weaker position. But I was asking somebody, because we talked about the relief duty the other week, and the question was, and I was a bit tired, the question was, what can you expect to get out of that? What's it really worth? And if it doesn't give you a right to housing, what's the point of it? And I raised this with a barrister, and they said, yeah, there's no absolute right to be housed. You can't say 57 days have gone by, you've discharged the duty and I'm homeless, so I'm going to court. But, this is a big but, they have to prepare a personal housing plan and they have to assist you. They have to take reasonable steps to help you get accommodation. And so you could challenge, if the housing plan is, as is often the case, is not very good and doesn't show a proper analysis of your problems and the steps that they need to take, you could challenge that. And so the question is, the personal housing plan, in order to be any good, should result in you getting housed. If there's a personal housing plan and you don't get housed, it's likely to be inadequate.
And I guess the argument works if you engage fully with it. So if you didn't cooperate with it, then obviously the council, yes, they're not at fault. But I guess what you're saying is, if they have a duty to kind of make an effective plan and it's not effective, then they failed to make an effective plan. So I mean, I guess my next question on that is, are you aware of any case law where that's been the argument? Because I think that'd be an interesting one to sort of see go through to the courts and actually explore.
I'll have a look at it in more detail, but what tends to happen is that decisions do get challenged on the basis that they haven't discharged the relief duty. And I'll have to go back, and again, I'm not aware of any situations where the judge says, right, give them accommodation because you haven't discharged relief duty. But I'll look at it again, and I'll talk to other people, and I'll try and come back with something more definitive.
Yeah.
But not to
That's
give
helpful.
up, because to get hold of that personal housing plan, and if it is rubbish, then go for a review of that. And it might be that as a result of that, somebody actually does find you somewhere.
And yeah, then just to point out, the council's got various ways of housing you that doesn't involve an actual duty. So things like your rent deposit schemes and rent in advance and all those kind of things would potentially kick in there. Yeah, hopefully that's a helpful answer to that question. Another question here is, so can someone bid in 2 cities and basically basically accept the first offer that comes up? So interesting one. So bidding, bidding, I guess, is referring to being on the housing register and being active and being able to place bids on the properties that you like the look of. My answer here is it would depend on the local authority, because every area is going to have a different policy on whether or not you can be live somewhere else. Because certainly in my experience, most housing registers will say specifically, have you applied to a different council as well? And my assumption would be with that is if you have, they'd say, well, no, we won't accept you then. But it will certainly be possible to have local connection in 2 areas, even under Part 6 of the Housing Act, the Housing Register strict criteria. So my answer is it's possible, unless the local housing allocation scheme specifically says you can't do it. So if you Google your local council and in Bedford Borough Council local housing allocation scheme, sorry, get mixed up there. So housing allocation scheme or housing allocation policy, you should get policy. They're usually between 10 and 30 pages long, so they're not short, but they should be divided up. They're usually divided up into fairly straightforward sections, which basically there'll be like ineligible persons or something like that, a kind of a section like that, which is not there talking about eligibility in terms of recourse, but saying actually there are certain people who can't get on the register. So one example would be some councils will say, well, if you've got rent arrears, we won't put you on there. If you've got antisocial behaviour convictions or whatever, you won't be on there. But they might say, for people who've actually applied somewhere else, we won't take you. But it's not definitely impossible, is my answer.
Yeah.
What about you, Will?
Well, while you were saying that, I just went away and I thought I'll pick a housing allocation policy document at random and see if I can find an exclusion. And I chose the London Borough of Westminster City Council because I thought, well, they're going to be quite restrictive about who can have stuff. And they've got a list of exclusions, and there's 13 different exclusions, and I can't see any that says if you're on the housing register somewhere else. There's lots of other ones, like if you've applied to a local authority for assistance under the Housing Act 1996 and been found intentionally homeless within the last 5 years, and weird little things like that, but not that one. So I think you could have a go and see.
Just to illustrate the differences, so the training I was delivering with Shannon back on Monday, like their local housing policy, basically you get local connection if you've lived there and settled accommodation for 2 out of the last 5 years. But I'd imagine Westminster is probably like, has to be the last 15 years consecutively. So there is a lot of variation between areas, particularly the further away from London and the big cities you go, the more relaxed they'll be. So yeah, we can't give you a definitive answer, but check out your local housing allocation scheme and you should hopefully get an answer there. One sense, I guess it's probably important to say that you can't lie in your application. So you can't say that you haven't applied somewhere else if you have.
Yeah.
Because if you get caught, it's not going to go well for you. So yeah, that seems like to be an answer there. Will, have you got to shoot off at 8:30?
No, I can hang around.
Cool. Okay. Yeah. Okay. So this is an interesting one for me because there's some jargon here which I think is quite interesting. So, question: can someone get housed when they are statutorily homeless, as in main housing duty accepted and as a homeless household? So, before we answer it, I just want to kind of check that my understanding of statutory or statutorily homeless, what it actually means, because I know that local authorities mean it to mean people who had the main homelessness duty accepted, But my reading of that term should mean that anyone that the council's found to be homeless, irrespective of whether they are in priority need or whatever. So, Will, have you got any kind of experience of the kind of that bit of jargon being used in terms of statutorily homeless?
Yes, let me think. It comes up with overcrowding in the sense that now let me think this through. Sorry, that's statutory. Sorry, that's statutory overcrowding. I'm thinking that, and I was just looking to see if there was a definition of this, but I think statutory overcrowding means, statutory homelessness means that you have been accepted as being homeless for the purposes of the definition in Part 7.
That would be because the reason I was interested in this is I had a real big bugbear, and I might get this wrong. Ooh, I'm not going to name that. There was a national homelessness charity, and on their website they had some really stupid advice. So it said stuff like, "If you have no local connection, the council can't help you." And I'm like, so yeah, it's nonsense. They can. And they use that term statutorily homeless. And again, they just kind of mangled it up, and they kind of, they just gave some really bad advice, and I complained about it to them, and they changed it. They didn't thank me for it, but that's National Homelessness Charities for you. But that term, so as I say, yeah, I think that term means that someone's, meets the statutory definition of being homeless itself. But in terms of the answer to the question, it's a really easy one. The answer is yes. So can someone get housed who's owed the main homelessness duty? Yes, absolutely. Or the main housing duty. We use those terms interchangeably. The answer is absolutely yes. But it might take years. Again, it just depends where you are, whereabouts in the country. So outside of London, it's not unusual to be a few months or, maybe 12 months. But in London, it's likely to be, well, it's not unusual for it to be five years, if my understanding is correct. I don't work in London, luckily. But so it will depend where you are. But yeah, if the council owes you a duty, owes the main housing duty to you, they have a duty to, basically support you into settled accommodation effectively, whether that's in social housing in terms of Part 6 or whether it's longer term private renting accommodation. So under the main housing duty, it's got to be a 12-month tenancy. I don't know how that's going to change with the ending of Section 21, but
no, it's all up in the air, that, isn't it? Can I just add a couple of things to that, because I was trying to think. Looking at it the other way around, when would somebody be homeless who isn't statutorily homeless, or what's the difference between some other concept of homeless? And the only thing I can think of is that sometimes the term street homeless is used to distinguish it from statutory homeless, because you can be homeless at home, which is where your accommodation is unreasonable for you to continue to occupy, but you're still homeless. But you're not street homeless. So you only have to establish statutory homelessness. And the other thing is, and forgive me if you said this, but the main housing duty will not be owed simply because you're statutorily homeless. You'll have to jump over the other hurdles that they put in the way. So the first one is a local connection with somewhere or nowhere, because if you've got no local connection anywhere, you can apply anywhere, because the test is not you don't have a local connection, it's you've got a local connection somewhere else. Then you've got priority need and intentionality, and obviously immigration status. So if you can get over those, then you would be housed both temporarily whilst they find you somewhere or make a decision, and then housed in the longer term. But sadly, I tend to find now that I'm having to find the distinction between temporary accommodation and permanent accommodation is getting thinner and thinner now, so that somebody placed in a reasonable private sector place, it doesn't really matter. I mean,
in many situations, it's longer term. So as you say, like people can end up being in temporary accommodation for years, and actually, that still has to be suitable under the law. So you can have people who are actually more settled in temporary accommodation than they would be if they moved into a 6-month or short hold tenancy, potentially in effect, because they can move in somewhere and then they get evicted 6 months later. Whereas actually under temporary accommodation, the council can basically say, look, you're going to be here for years, because these are the average waiting times. Or people, I've said it elsewhere, single mums affected by the benefit cap, or single parents affected by the benefit cap, they are basically trapped in TA, because the benefit cap only applies when you're out. So it doesn't apply when you're in TA. So they can afford their rent in TA, but they can't move out because as soon as they did, they wouldn't be able to afford it again. Cool. So there's another question coming here. How does the Homelessness Reduction Act 2017 come into play? So good question.
Well,
I
yeah,
mean, it's kind of like so broad, I'm not quite sure where to start. The HRA, what the HRA didn't do was change the 5-part test. So they didn't change the definition. Well, it might have kind of amended very slightly, but largely speaking, the definition of homelessness, the definition of eligibility, priority need, intentional homelessness, and local connection didn't change, although it did, the HRA did affect the order that you look at it. So local connection used to be the 5th test you do. Now it's effectively the 4th, kind of. So you know, once you've kind of looked at homelessness, priority need, and eligibility, you could then look at local connection. In terms of, you know, I'm still coming to terms with the differences it made. So for years, when I was working at Just Us, me and John just kind of, we just literally just pretended like it never happened. And actually that didn't really affect the arguments we made about priority needs, getting people that main homelessness duty. What I've only found out recently, and is after I did a video on YouTube and I found out I was incorrect, was that in that 56, so there used to be no relief period. So you make a homeless application, a council could accept the main homelessness duty on day one. So for some, you know, for a family fleeing domestic abuse, they would, you know, they could do that and immediately say, yeah, we're going to owe you a full duty. But now you've got this 56-day relief period, which only kicks in once the council's actually satisfied you're homeless. So that's another video I've got going correct, because you might make a homeless application, give them reasons to believe you might be homeless, and then it takes them 3 weeks to actually be satisfied you are homeless, and that's when the relief duty kicks in, and then their decision can be another 56 days past that, which is so annoying. But anyway, so yeah, you've kind of, yeah, the HRA comes into play in terms of that prevention and relief duty. It delays everything in reality. If you're, I think this is where I would sit on this, Will. So if you're a lawyer like Will is, the HRA gives a lot of ways in which you can challenge things indirectly. So you might be challenging the suitability of accommodation because they didn't do the relief duty properly. They didn't do a proper assessment. They didn't consider the right facts. And that then led on to a cascade of unlawfulness which then resulted in the challenge that you can win about the suitability of TA. So that's, you know, so the big changes that the HRA are, the relief duty is, you know, this 56-day period where you're in limbo, really, in my experience of the people that are in that situation. It just delays everything. You've got personalised housing plans, which are a really good tool that you can challenge on. If you get your PHB and you say this is no, there's no detail in this, or you've missed that X, Y, and Z. You've got the duty to refer, which are this duty on certain professions like police, prisons, A&E, where they have to refer someone who they think might be homeless, but it doesn't result in a homeless application, so it's not particularly helpful either. Lots of hospitals, I keep meeting hospital social workers like, we don't bother with that anymore because it never works. I'm like, because you're not making a homeless application, you're only making a duty to refer. Anyway, and that's all I can think of. That's the you know, the kind of the highlights or the headlines. But what, you know, what else? I mean, I don't. We could talk all night about this, but what would your headlines be, Will?
Well, my first headline would be, it gives me an opportunity to quote my favourite ever historical quote, which was something that Chinese Premier Zhou Enlai said in 1949. Somebody asked him, what are the historical implications of the French Revolution? And he said, it's too soon to tell, which I thought was fantastic. And it's a bit like that with the answer to this question, was it's a bit too soon to tell. It's only been 6 years now and people are still scratching their heads. But I'll tell you, the bottom line, I think you've made the points there. The thing is, the 2017 Act was passed with very good intentions by people who had obviously analysed the way in which the law and the system failed until then. And one of those is why you've got to have this personal housing plan, is because they said, really, you in the past, they were just looking for excuses not to house you. So the whole assessment process was all, let's try and find a reason that we can trip them up on one of these hurdles that I just mentioned. And then when you got offered something at the end of that, it was like, you should be grateful. We don't have to actually consider what's suitable for you. And what the personal housing plan requirement involves is a duty to carry out a detailed assessment. You don't just draw up a housing plan, because that would be easy. You just say, find you somewhere to live. You're supposed to do that as well. But they actually have to assess 3 or 4 key things. Number one is how you became homeless. Number two is what you need in terms of what's suitable for you. And number three, so it's only 3 things, is what support you need in maintaining that accommodation. So just as an example, which I've just realized I missed when we were talking about the smoke and urine example, is that you could challenge a homelessness decision. In that case, a Section 202 ground would be, I've had a look at the personal housing plan. There's no indication that this involved an assessment of the needs of the family, and therefore you haven't got any information on your file to determine. You can't talk about suitability because you haven't got any evidence. So your decision is irrational because it's based on no evidence. And that will work quite a lot of the time. So that's an example of one little thing that it can do. It's really should be seen as a sort of, it doesn't replace the old law in any way, I don't think, apart from little tweaks like that thing about temporary accommodation. But it sort of seeks to mitigate some of the worst aspects of it. And it gets us close. The relief duty, without going on and on about it, the relief duty is as close as you get to saying everybody should be housed. Let's forget about this priority need nonsense. And just, if they're homeless, they need a home. You can't quite go all the way there because local authorities will be saying, well, we might as well give up because you just told us to house everyone and we can't do that. But it's pretty damn close. So that's a long answer to that one. I hope it's helpful. Oh yeah, you said very helpful. Thank you.
Just on that, Will, so I don't know if you know the answer to this because it's a question about Welsh law. So I read in the Welsh Code of Guidance, something said along the line, it said, people who are rough sleeping are very likely to be vulnerable, or words to that effect, which is not something it ever says in the English Code of Guidance. As far as you know, is the case law in Wales on priority need the same? Is it still HOTAC? Is it still, Smith v. Haringey and Paniotu and all that sort of stuff, as far as you know? I think
so, although if there is a different, there is different law in Wales, isn't there? There's the
it's not too dissimilar. It's similar enough there to be combined textbooks on it, put it that way.
They were ahead of us on domestic abuse because there was a thing you're automatically in priority need from domestic abuse, which I think is now the case here, but wasn't the case in here while it was in Wales. But I think the test is still HOTAC, Paniotu. And again, this is a bit like we were saying about personal housing plans. And I often think this when I'm sort of walking down the street and I see somebody sleeping rough, because I think, well, there's some sort of hopeless romantics who are unrealistic that say, oh, people, they've got a right to sleep rough, and if they want to do that, and which I don't accept at all, especially on a wet winter's night. But if you're out there, you've obviously fallen through the cracks. And so you must, if you dig deep enough, you probably find that somebody's vulnerable because they have failed to deal with the consequences of homelessness because they're still homeless. And they are probably going to suffer harm if they're out there on the street. And when you're talking about the younger and, or older you get, the more likely you are to be at risk of exploitation or violence. So I would have thought, and the other problem is that, I don't like to characterize all rough sleepers as having mental health or behavioral problems, but there may be lots of reasons why somebody's there. So I find it very hard to think that anybody rough sleeping, if they wanted to and they were motivated and had a decent lawyer and access to medical services, then they could get accepted as in priority need. So I'd have thought that's the same everywhere, but maybe I'm being naive.
I don't think you're being naive, but I think you're certainly swimming against the kind of the stream at the moment of homelessness sector, because they've got the whole verification process, which is basically saying to people who there's very much, there's always, in my opinion, there's always going to be reason to believe the person might be in priority need. So the Section 188 duty should kick in if they're eligible for assistance. But they're being told, oh no, go and rough sleep and we'll come and find you. And but we've talked about that elsewhere, so I won't go on about that. There's actually, Will, there's a question as well within the ones we had in the week, which I just thought is an interesting one as well. So it's number 5 on the ones I sent you. So single mum with mobility issues lives on the 4th floor. They're renovating the lift and it will take 12 weeks. and they were given less than 4 weeks notice of this. So what help can the council provide, and how does support network and schools come into this? So basically, so essentially the council's going to rehouse it, but they've said, oh, it's going to be, you know, whatever, 200 miles away or something. And what she's already raising as well, you know, what about my support network? Because I'm pretty sure because of her disabilities, you know, looking after a kid is particularly difficult, and also kids at local schools. So, but it's an interesting one. I think it's interesting because, you know, this is only going to be a 4-week period. You know, we know this is she's not homeless, but she's only going to be homeless for that 4-week period because there's going to be no lifts in the building. So it's not reasonable to continue to occupy that property whilst those lifts are out of service. But then the council's saying, well, yeah, we can help, but it's going to be hundreds of miles away. Again, this is kind of reiterating some of the stuff you've already said, Will, but like, where's
the hundreds of miles away bit? I can't see that.
So I think because I anonymised it came in from someone that had a lot of other information, but it was the council said, yeah, as I say, they're looking to house a well out of area, basically.
Okay. So I think the thing with this is sort of, my approach is a bit sort of like untangle the threads and sort of look at the building blocks. So the question I would have thought, as you're saying, that they are homeless because they have mobility issues and they can't access the property. So they don't have accommodation available to them. The fact that it's only for 12 weeks, I don't think changes anything, because you say, well, the law doesn't say it's got to be accommodation that's unavailable forever or will never be available. So I think you could have a go at doing that. And the question of suitability and the accommodation miles away is just the usual issue of, once they've accepted a duty, and then presumably if there's a child there and or somebody's got medical issues, they'll be in priority need, and they're certainly unintentional, and they've got a local connection because they've applied to their own authority. So there's a duty owed there. It's a question of suitability. And they could say, well, I mean, the one problem is that the shorter the time you need to spend in the temporary, they may be able to say the further away it can be. But again, it's just the same old argument, really, because if you need a support network every day, then one thing I would say, and I said this before, but support network is a term that is used quite a lot in this context. And suitability, people will often refer to the need for a support network, and people don't actually break it down and say, well, what are you talking about? What is your support network? Is it somebody that somebody that looks after your kids if you're ill and picks them up from school? Or is it somebody that helps you choose your medication? Or is it a professional person, or is it just your friend? My advice to people is that there was a case about 10 years ago. It was a Westminster case on suitability, and I think they housed somebody from Westminster out in Newham, which isn't actually all that far. It's about an hour on the, well, no, less, 45 minutes on the tube. But they said, oh, we've got a support network, and they said basically, no, you don't need a support network. There's if you need help, you can get it from social services, and there's social services in Newham, and they lost the challenge. And I think from one of the weaknesses you get to is, if you're talking about support network and you get all the way to the challenge, and they'd say, well, you haven't said why you need support, what your support network is, what it comprises, and also I just did it this week. I got somebody to write a letter saying, or an email saying, I am so and so, and I provide this support for the person. So the support from the network and the schools comes into it. And again, the schools can be very helpful if they say, well, this pupil needs to be here, and they're getting support from the school as well. So again, I suppose the simple answer is the support network and schools comes into it as much as it ever does, but don't forget that you need to identify what that is.
I mean, it's also interesting because if it's going to be 12 weeks, the kid's going to have to either miss 12 weeks of school, which if it's over summer holidays, okay, miss 6 weeks of school, or they're going to have to move school twice. They can move to another school, which is just not practical. It's not going to happen. So they're going to miss loads of school, basically. And there is some stuff within, I can't remember what guidance is, we've talked about it before, which basically says that children, it's not suitable to be housed more than 45 minutes away if you're primary age kids, and an hour and 15 if you're secondary age kids. Now, there's additional issues here, because if the mum's got mobility issues, then that becomes even more difficult potentially, because it might be impossible to kind of expect a primary school age child to go into a 45-minute journey without a parent, if that's not going to be possible. So it seems like a letter from the school and a letter from the kind of professional supporting, saying what that's going to look like. If they're housed in Birmingham and they're from London, what these are going to be the impacts on that family.
Yes, and there's another thing, just as a little gem which people forget, is that even if it's not that far away, if we're not talking about a different city, even if we're talking about an hour, more than 45 minutes away on the train, that one of the leading cases on this, it's easy to take your eye off the ball, but I didn't realize until I heard this, that there was a child who was going to school, and I think the parents were placed in somewhere in East London and the school was in South London, and it was about an hour and a half each way. But there was another child who was in a buggy, and obviously that child was going with the mother to take the child to school, and was then going to the school, back again, back to the school, back again. The poor child was spending its whole life in the buggy on the public transport, and they said, well, that's completely unsuitable. And I hadn't thought of that. So it's worth thinking into all of the issues like that.
Yeah. Okay. Cool. We've got some other bits we could talk about, but that's sort of questions I think either from the week or in the live chat. So yeah, I don't know, do we want to, I've got another 10 minutes in me, but we've got some other kind of themes we wanted to talk about potentially, but have you got another 10 minutes in you, Will?
Yeah.
So we've got, there's 1 and 2 on that list. Well, I don't know if you've got a all that local government ombudsman case.
I haven't. I must confess, I haven't had a chance to read that, and I'd like to talk about that in more detail and the issue of capacity.
Yeah, let's save that for another week then.
So we should have a special on that one.
We'll do a few minutes on making effective complaints.
Yes,
because most of the questions that people have got, the answer is make a complaint, and all I can say is complaints are actually very, very effective if they're done correctly. So as a non-lawyer, I'm probably got more experience of this than Will does, because that's kind of my only teeth is to make a complaint. I get kind of politicians involved and whatever. So I guess I've got some key, key standard things around making complaints that are probably helpful. I won't talk for very long, but just there's some key things you want to do. So if you're in a situation, if you're ever in any situation where things are not going well with the council, the first thing you need to do is make a subject access request, which is basically the fancy term for getting a copy of all your records from the local authority. So technically, subject access requests can be made in any particular form, so you don't have to fill in the council's form, but you might as well. And within that site, be on the website, if you just Google Bedford Borough Council subject access request, it will have like either an online form or like an email address or something like that. And you just need to email them, and you need to specify what it is you want. So it might be say, well, I want everything you've got, and you can do that, that's legal. But it might be more sensible to say, well, actually, I want everything from the housing team, everything the housing department's got on me since January 2023 or something like that. It just covers the period you've been dealing with them. They've got 30 days, so 20 working days, to respond to that. Most councils won't respond to you within that time, so you're going to have to make a complaint about that as well. But it's worth it, because when you get the full file, there'll be loads of, if you've been failed by a council, there'll probably be evidence in there. Obviously, there's unlikely to be evidence about someone being rude to you, which is a valid complaint, but it's probably not going to get upheld because there's not going to be proof of it. But anything around, delays in providing temporary accommodation, it will be in there. Reasoning, kind of all the letters they do, all the evidence they've got will all be in there, which you can then start looking through and picking apart. And once you've got the subject access request, the first thing I do is I put it in chronological order. So I basically, do a chronology of, this date was when you first made a homeless application, this date's when you offered it, blah, 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 blah. So you kind of have quite a long complaint potentially. And then when it comes to actually making a complaint, when me and John started Just Us Up 10 years ago, it was now pretty much, the first complaint we ever submitted to the LGO was like 30 pages long, and it was beautiful. It was bound. It was beautiful. And these days, I don't bother with that. It's just you need half a page, you need bullet points, and you need to be very, very clear, very, very quick on what it is you're complaining about. So it might be, literally point one, I wasn't offered temporary accommodation when I should have been. And then you just put a paragraph in saying, I made a homeless application on this date. I told the council I had X, Y, Z medical issues, and they didn't put me in temporary accommodation until Y date over here. That's point one. And point two might be, when I moved in, the accommodation wasn't suitable. Now, complaints technically can't be about the actual decision. So if they made a howler of a non-priority decision or something like that, technically the complaint's probably going to come back and say, well, we can't comment on that. You need to go down the section 202 review route to get an answer to that. But that doesn't mean to say it's not actually useful to make a complaint about stuff. I've made complaints about stuff knowing it would not be upheld for that reason, but it still led to good outcome for the individual and systemic changes and improvements in the service. So you can, still worth complaining. If you think you're right about something and you think you've been fair and everything, you need to make a complaint. Another thing, back in the day when I first contacted the LGO, the first thing they said to me on the phone was, don't worry about the council's formal complaints process, just send the complaint to the chief exec straight away. And when I'm dealing with a council I've not dealt with before, that's the first thing I do now. So it's different if you know the council, you know who you're dealing with. But if you are starting this afresh, make a complaint to the chief exec. All the information, that the chief exec's name will be on the council's website, and copy in any relevant councillors. So your ward councillor, you might have more than one, it might be 2 or 3 in your area. The councillor who deals with housing, if it's an issue around disabilities or something, the councillor who deals with social care, all of those things, you want to copy them in, because they are ordinary, decent people most of the time. They see a situation like one of the questions we've been asking tonight, they're going to be like, hang on a minute, this doesn't sound right. So that the lady, for example, who's got a severely disabled daughter and has been put in unsuitable accommodation, they would potentially, kind of wade in there and get a good outcome without having to go down the legal routes. So there's probably more I can say about this, but that, I would say always be quick to complain. If the housing officer's not responding to your emails, complain. There's no other way of doing it. You need to complain. Those complaints do have an impact, and they have a positive impact in terms of service provision as well. So you're not just improving the service for yourself, you're basically flagging an issue within the housing team where someone outside the housing team will get to see the nature of the complaint. And if it's a decent council, they'll start looking at it, think, hang on a minute, we've got 10 complaints this year about delays in responding to emails. Well, we might, this is another good argument to have more housing officers. So I think that's kind of the stuff which is off the top of my head. Always complain to the chief exec, always make a subject access request, keep them short and sharp. Don't think that adding lots of words to it is going to make it a stronger complaint. In some cases, it actually makes it weaker, because if you say, I didn't want this accommodation because I've got a disability and it's not suitable, that's one thing. If you then say, well, actually, I didn't like the colour of the wallpaper and it's a bit too far from the shops and all those things, a housing officer will look at that and think, well, do you know what? Yeah, it's not really about the disability. It's about these other things which you don't like, which actually we don't need to take as much attention to. Hey, Shannon, just on the chat there. So just to say that someone can complain on your behalf as well, which if you're a professional, you should be complaining on your client's behalf if they want you to. You need to show that you've got their consent, obviously, but absolutely you can do. It is highly unrealistic to expect homeless people to actually hold their own in this process. They are, they're walking in, ignorant, not in a bad sense, but they just don't know about the law, and they are at the whims of a housing officer who definitely does know the law and also will be knowing how to kind of play it. So you're kind of a lamb in the lion's den, or whatever the saying is. So you want to make sure you've got people, you want to make sure your clients are supported to actually have a robust comeback on kind of council stuff that's unlawful. So do you know what? We've got 16 people watching, which is, it's just got higher. So I just want to say something about number 2 there as well. Well, if you've got 2 more minutes, and this is a comment that you might not want to talk about this, I don't know, but so it was on a YouTube video I did recently, and I don't know what the video actually said, but it was obviously criticising housing officers at some point. And basically the comment was, with housing officers, in all fairness, there's only so much they can do for you. And I couldn't disagree more strongly with that position, and or certainly have some caveats for that. So the idea that housing officers are under pressure and it's not their fault, that things are so bad, and it's not their fault, they're unlawfully denying housing to people and all those kind of things. Ethically, I think it's very difficult to defend yourself if you're a housing officer and you are the one who is telling that vulnerable person that they're not vulnerable or whatever. So I would say, we're going to do an event on this later in the year called the Ethics of Gatekeeping, but I would say that if you're a housing officer, unless you have raised the grievance with your boss, whistle blown, tried everything you could possibly do to put pressure on your employers to stop getting you to break the law, then I would say it's a pretty shaky thing to say there's nothing more housing officers can do, because they can do those things. And actually, if we have a sector which is operated by housing officers who all are, they're unhappy and they're grumbling about the unlawful stuff they have to do, but they're not a difficult issue, because obviously I've just been very clumsy there in what I'm saying, but there's a side to me which says it needs to be said, and also a side to me which I think we need to just kind of work out how we actually get an effective message. So yeah, Will, do you want to say anything about that?
Just a tiny bit. I mean, I just going back to the complaints bit, I would really like to talk more about complaints, because obviously you and I are coming at this subject from two different positions. You're in more the complaint culture, and I'm more in the legal challenge culture. And so we don't do the other thing that the other does. But in an ideal world, I would think that the complaints route should work, because then the system has a built-in redress mechanism and is accountable, and you shouldn't need to find a lawyer. You should be able to make a complaint. And so, but obviously that's not going to work 100%, but the more that things that you're suggesting are adopted, the more it might work. And I'd be really interested in exploring that. And so maybe we could talk about that more another time. And I guess my comment on the housing officers thing is I suppose it's a bit like that, that saying about democracy, that if democracy changed anything, they'd make it illegal. That sort of idea that if housing officers did try and help you, they'd probably get sacked. But I always think with housing officers, I spend my life hassling them, and so I feel guilty. Also, I do sometimes feel a bit cynical about what the job can do to you. But I think the problem is you get people who genuinely take up the job. It's not a well-paid job. It's very challenging. So people aren't doing it for the wrong reasons. But I have the feeling that a lot of the time there's somebody sort of in the back office, there's a manager who sort of calls them in and says, "Oh, you did this and this and this," and they get sort of molded more into an unhelpful situation, just to recognize the fact that the system, those that run the system say there's only so much we can do. And the worst scenario with that now, and I think people are in danger of accepting it, and it's part of this sort of culture that we have now, or the feeling that the welfare state is just breaking down, is that social workers, adult social workers supposed to help mentally ill people. It's almost impossible to get them to do that. And again, that brings us back to complaints, because I would like to talk about that, because it's very difficult to get legal challenges off the ground on those sorts of things. So I think that's it for me. All respect to housing officers, and it's easy for them. It's easy for me to sit here and hassle and criticize them, but in some ways they've got the tougher job than I have of helping people and getting criticized for it. So I won't say any more negative than that.
Yeah, cool. Maybe it's a case of finding out how to take aim at the structure and the hierarchy that's putting the pressure on housing officers to do it. But I think that's gonna be a recurring thing as well in the coming months anyway. But yeah, cool. All right. Well, thanks, Will. I feel like we covered a lot of ground there. As always, all gone.
Gone by very fast.
Yeah. If you want to just like and subscribe and all that YouTube business, we do this every week, we're aiming to do it every week. So I'm sure some weeks we won't do it. But yeah, we will. If you kind of put a question in the comments, just first of all, don't put your personal information in it, but just say it as if it's about someone else. But we compile a list during the week, and then we pick up on the ones which are kind of the most interesting in that sense, or the most informative, and we'll kind of use them. So yeah, and obviously Shannon, who's not with me tonight, is basically does training with me. So we do like online training every so often. So check us out on Eventbrite and stuff like that as well. And yeah, cool. We'll see you next week. Thanks, Will.
Okay, bye-bye.
Take it